Hi, my name is Tracy Lee. I'm with County Counsel's Office, and I represent the Child Welfare Agency in a juvenile court.
My name is David Myers. I'm a lawyer who represents parents and children in dependency proceedings.
My name is Jennifer McLaren, and I'm also with County Counsel, and I represent the Child Welfare Agency.
So if you're watching this video, you're probably heading into either your first jurisdictional dispositional hearing or your first jurisdictional hearing. Some counties handle the hearings separately, some handle them together. No matter, we're going to be talking about them separately here. So your report's been filed. It's your expectation that everything's going to sail through. The court's going to adopt your recommendations and turn them into court orders, and you're going to move through. We want that to happen, but why doesn't that always happen? And how can we ensure it does? This video will provide a look at what happens around you from the time your report is filed until the court makes their orders.
There's a lot happening between the time of the detention hearing and the time you come back, and you're only involved in some of that. Hopefully the clients are talking to their lawyers, the kids are talking to their lawyers, the parents are talking to their lawyers, and of course these cases are fluid, so they're always changing. You know, they're clean one day, they relapse the next, and then of course you have all these people around you who are trying to get their needs met, like relatives and service providers. Jen, can you tell us a little bit about just the law at play when you walk into the courtroom for these hearings?
I can. So jurisdiction is covered by Welfare and Institution Code Section 300. And in order for the court to sustain a petition, they have to determine that the facts and evidence support the allegations in your petition. The petition can be 300A through 300J. If the court is unable to make that finding, then your petition is dismissed and you never get to disposition. The burden of proof for the jurisdiction hearing is what is called preponderance of the evidence. It is a very marginal burden of proof. Essentially, if you have two scales and it tips that way, 51%, and the court is convinced that your evidence is true, you've met your burden of proof. Juvenile welfare is meant to protect children. They don't want to have lengthy court proceedings, and so they've made the burden of proof preponderance of the evidence.
Now this is different when you get to the dispositional hearing. It's a separate hearing, even if it's held together, with very different law. Tracy, can you talk a little bit about that?
Sure. So we're still, of course, under the Welfare and Institution Code, and you're looking at Section 360. And once the court has determined that, yes, this child is described by Section 300, i.e., the court has jurisdiction over this child and the family, then we move to the dispositional section and looking at now what. So what can the court do at that point? Dismiss, not assume jurisdiction, not adjudicate the child a dependent, could go for informal supervision, could look at upfront guardianship, could look at informal supervision, and in most cases, at least in our county, it is to formally declare the child a dependent and set forward into the foster care system. The burden of proof in the dispositional hearing is a little higher. You heard Jen talking about the preponderance of the evidence. More likely than not. Clear and convincing is a little more than that. Highly, substantially more probable to be true. It's not beyond a reasonable doubt like in the criminal courts, but it's not preponderance. Somewhere in the middle.
Right. And these two hearings, the jurisdiction dispositional hearing, they have very big consequences. Unlike a detention hearing, which is a temporary removal, which of course is a very big consequence, but a short-term consequence. Jurisdiction and disposition have long-term consequences. Tracy, can you talk a little bit about the consequences of a jurisdictional hearing and why that matters, and then we'll get inside the courtroom.
Absolutely. The government is coming into this family. And for the government to be able to come in and tell these parents how to parent, there has to be a strong reason for that, a compelling reason for that. And as we know, every time a child is removed or the government comes in and interferes or involves themselves in a family, it's very traumatic. There's something going on in that family that is very traumatic. So the court, the legislature, and the courts find that the jurisdictional hearing is so critical. It's that entry point into the dependency system.
That's right, and consequently a dispositional hearing carries a number of consequences as well.
Right, if the child is actually removed from the parents and the court's made that finding by clear and convincing evidence, that starts the time frame for the statutory right to reunification services. The parent has a very short amount of time to mitigate the circumstances that led to the children being removed in the first place. So it's important when there is a disposition hearing and there is a removal order that everybody understands that that time frame has started.
These hearings in some counties are always contested, just naturally default into that. Why? Because they're a very big deal, and a lot of times parents have nothing to lose, so they will set these as contested hearings. And so no matter what you do, it's still a fight. But sometimes you haven't done everything, and sometimes parents are able to access more information or evidence than you can. And so sometimes that happens. And then, of course, as we talk about the gray areas, there are legal concepts, one of which is nexus. If you're in a safety organized practice county, you'll hear about behavior and the impact to the child. We call that nexus, and we call that sometimes the behavior itself may be bad, but it doesn't necessarily impact the child. This is the time, these hearings are the time to fight about all of those concepts. So, Tracy, how can social workers ensure that courts adopt the recommended findings and orders?
I think you have to go back to the code. Understand what you're alleging, what your allegation is in your petition, and what evidence do you have that supports that allegation. Embrace your role as a neutral investigator. Engage with robust curiosity. Important to tell all sides of the story. We have biases. All of us do. As much as you can, check your biases. Know that they're there. Present a clear picture. State your facts clearly so that the court understands what you're saying. Support your conclusions with evidence. Why are you making that recommendation? And lastly, use the supports that are around you. Big plug, use county counsel in this area. This is very important. And use your mentors around you, your supervisors, your program planners, your trainers.
And the same goes for the disposition hearing. You know, you want to make sure that you present a good social work analysis of the family's strengths and needs. You know, like Tracy said, you want to tell all sides of the story. You are a neutral investigator, and you're helping the court make an important decision with respect to the children and the families. So you need to support all of your conclusions and your analysis with the evidence that you've obtained during your investigation. You need to understand what the issues are with this family so that you can make recommendations with respect to their services and what their needs are. And you're not in this alone. So if you find yourself struggling with what you should be recommending to the family, again, reach out to your supervisors, your coworkers, and most importantly, your county counsel.
And so how these court hearings actually present themselves is going to look very different from courtroom to courtroom, from county to county. But if you understand what we've been talking about today, you're going to have a much easier experience even when everyone around you is fighting.
And we hope that this video helps you get through your jurisdiction and disposition hearing.